Welcome back. This is part two in the video series that takes a look at Florida's indictment against the officer, Scott Peterson. Scott Peterson was on duty at the time of the Parkland shooting. Many of you know that a student, Nicholas Cruz, he basically goes into school and he shoots up a lot of people. So now, not only are they looking to basically send Nicholas Cruz to jail, but they found video of an officer who was on duty at the time, and they said, hey, he's a coward. And basically, because he was a coward, a lot of these students were killed. So we're going to look at that indictment, and I'm going to give you my thoughts and comments about that indictment. So I have here with me the statute, or one of the statutes involved in this indictment. And essentially it's 82703, abuse, aggravated abuse, and neglect of a child, and the penalties that go along with it. So basically the definitions is using this section, the term aggravated child abuse occurs when a person commits aggravated battery on a child, willfully tortures, maliciously punish, or willfully and unlawfully cages a child, or knowingly or willfully abuses a child, in so doing cause great bodily harm, permanent disability, or permanent disfigurement to the child. So that's the actual definition. So let's look at the first count, which is going to be 827.03. And forgive me if I don't get this right, because this is really confusing in terms of actually how they, I guess, label the count. So basically we're going to look at 1E1 and 1E12. So let's see if we can find that. So anyway, let's get into it. I believe this is it. So E1, a caregiver's failure or omission to provide a child with the care, supervision, and services necessary to maintain the child's physical and mental health, including but not limited to food, nutrition, clothing, shelter, supervision, medicine, and medical services that a prudent person would consider essential for the well-being of the child. Or we're just going to go to 2, a caregiver's failure to make reasonable effort to protect the child from abuse, neglect, exploitation by any other person. So I think that covers the first sections of the first count. So 2B, let's take a look at that. A person who willfully, by culpable negligence, neglects a child, in so doing causes great bodily harm, permanent disability, or permanent disfigurement to the child, commits a felony of second degree, punishable as provided in these statutes, right? So that's going to be it for the first count. The second count, I think basically the only thing that's going to be different in the second count is that we're going to look at 2D. So let's just look at that. 2D is going to be a person willfully or by culpable negligence neglects a child without causing great bodily harm, permanent disability, or permanent disfigurement to the child, commits a felony of the third degree, punishable as in these statutes. So it looks like the difference between B and D is the amount of harm that's caused. One is great bodily harm, and one is basically not so great bodily harm, causing without great bodily harm. So in other words, the child is hurt, neglects a child without causing, the child is hurt or damaged in some way, but it's not severe. So it looks like they're trying to cover all their bases. So the third count basically is culpable negligent violation of Florida State Statute 784.05. I have that statute here, and we're looking for, I guess, the first part of it. Whoever through culpable negligence exposes another person to personal injury commits a misdemeanor of the second degree, punishable as provided in these additional statutes. So basically, somehow they're saying he's negligent and he exposed the children to bodily harm for the most part, and or injury. And then I think finally we have perjury, and basically that's going to be straightforward. I don't know if I actually found it. So yeah, so I found it. So basically perjury, yeah, so it's the entire perjury statute. Whoever makes a false statement in which he or she does not believe to be true under oath, not in a official proceeding in regards to any material matter, shall be guilty of a misdemeanor of the first degree, punishable as provided in these additional statutes. Knowledge of material of the statement is not an element of this crime, and the defendant mistakenly believes that his or her statement was not material, is not a defense. Huh, that's interesting. So, wow, that's actually crazy. So, even if you make a statement that you're not completely sure of, you can still be held to perjury. So, this, to me, this would make people not want to speak at all. So, you know what? Finally, I'm just going to go ahead and give my thoughts on all of this. To me, it just seems like most of these charges involve the person being a caregiver. So, I would have to wonder if a officer who is basically assigned to a school should be considered a caregiver. And I think if I was in his situation, I would say, hey, I was on duty to basically try to serve and protect. I wasn't here as the personal caregiver of these children. And actually, when I read through a lot of the statutes, to me it just seemed like they really just don't apply, right? So like let's look at 1B. I mean, let's look at B again. A person who willfully or culpably or by culpable negligence neglects a child, and in so doing so I mean, he didn't neglect the children in this case. I mean, the guy who actually shot the children, Nicholas Cruz, he's the one that should have to basically be at risk at going to prison. To me, none of this makes any sense. It looks like to me that they're really reaching with all of this, and I think that the officer involved in this probably should beat the charges. I mean, I would basically ask for a jury, and my defense would be basically that I didn't take personal responsibility for these children. I was just an officer on duty, and I would just say, "Hey, look, I was scared. The guy looks like he's close to retirement. I don't know." I would just say I was scared. I've had problems with this job. For I don't know if he's actually had problems, but I would say, look, I was scared. I've had problems with this job for a long time, and these problems included, me being afraid of dying on the job. So I was scared when I heard the guns. I mean, I would tell the truth. I heard the gunshots, and I was scared, just panicked, and I was scared. I was scared. That's the bottom line. So basically, I would back all that up with, probably going to my psychiatrist and just pouring my heart and my feelings out to my psychiatrist and say, hey, look, I'm afraid to die. Right. So to me, this just seems to be a complete waste of time charging this guy. So, but, let me know what you guys think. Leave your questions and comments below. Thanks.